Hi, everyone. I'm back. So Sandra Cho with Pointwealth Capital Management, and today we're going to be going over the markets, and then we're going to have a special guest, and he is an estate planning attorney, extremely well vetted, and I'm just very excited to have him, mainly because this is a wonderful opportunity for everyone to revisit their estate plan. As you know, I'm a huge advocate of having a trust, medical directive, power of attorney, and wills. So for if you're a couple, you should have two wills, two power of attorneys, two medical directives, and one trust or multiple trusts, especially when you have estate planning laws, certain estate planning limits, like, for example, the lifetime gift tax exemption and estate tax sunsetting January 1st, 2026, you do want to revisit that. And you'd be surprised. You might not think that you're wealthy. Well, you are. If you're with me, you definitely are. And wealth, after all, is also a state of mind. So be aware of that. But you do want to revisit these estate plans that you have, because you would be surprised how potentially low those laws could change. Those limits could change to, say, 1 million. Do we think it's going to change to 1 million? No. Could it happen? Absolutely. So you do want to consider that your primary residence alone would thrust the vast majority of you over that limit. Now, with no further ado, I'm going to be going over the markets. I wanted to let you know that I'm going to go over the some of the negative points before the positive. And I'm going to share my screen. I'm going to go over 5 slides with you that are going to highlight what's going on in the markets right now. First slide. Okay. So I don't know how many of you know or keep on track with the markets, but they are up for the year. However, even though they're up for the year, the vast majority of those gains is through a handful of stocks. So let's, for example, know that the S&P 500 as of yesterday is up 11.69%, 11.69%. And that sounds great, right? That has come down from around 18% earlier this year, but still being up 11.69, that's decent. If we could have that every year, I'd be happy. However, if you take out the top 10 stocks, then you would be looking at the rest being down 7.61%, 7.61%. So that's not great, right? You want to think about the fact that, most of you are up. I think that bodes well. But, it is a little concerning. This chart talks about that. And specifically, I wanted to highlight the 10 stocks that we excluded. These are the top 10 stocks. They're going to sound familiar to you. Apple, Microsoft, Amazon, Nvidia, Alphabet, Tesla, Meta, Alphabet C, so basically still Google, but a different share class, Berkshire Hathaway, and United Health. Obviously, Berkshire and United Health being this, these one-offs, everything else, specifically technology, right? And that partly is because of the whole AI, hype, which is amazing, but can also be kind of thrust mega caps up. You can see the health of the broad market being a little iffy, right? And that's something that this chart highlights. What this shows is that PE, which is profit and earnings, that median S&P profit earnings, the average historically is 16.1. The current is 16.6, slightly above the 25-year average, right? The valuation spread, what that means is, that means the top 20%, the biggest stocks compared to the still large stocks, but the smallest stocks of the S&P 500. That spread, that difference between the stock prices, that has increased, okay? So if the average 25-year average is less than the current difference between the stock price of the largest and the smallest of the S&P 500, what that generally means is that is going to narrow back to the average. Think of a rubber band. Rubber band stretches and then it goes back to its normal state, right? So that's what we would expect. And that doesn't mean that you should pile in to those smaller S&P 500 stocks. That just means that you want to be aware of it. We definitely are. We definitely have, made some changes in the portfolio. If you want more detail into that, we can go over that on a one-on-one basis. Now, next slide. So here you have, this is basically a different way of looking at that first slide and the information on that first slide. What it shows is that the PE ratio of the top 10 has a very wide volatility and has come up a lot. And if you look, it looks quite similar to the valuation spreads, back in late 1990s and 2020. Of course, we all know what happened in 2020. You had the tech bust, leading to the longest recession, which was 2020 to 2000 to 2002. Anyway, over here, the weight of the top 10 stocks, you can see the weighting of the top 10 stocks is almost 32% of the entire S&P 500, right? That's a high concentration. You might be asking yourself, hey, if the markets are up, 11+%, why am I not up 11+%? Well, it's because we are not betting the farm on the top 10 stocks because we know it's a rubber band and that rubber band will sling back, okay? And we don't want this to happen to your portfolio where you go up and you come crashing down, right? You do have exposure. It's just not all in there. And then now we go to the third slide. The third slide, by the way, this is all compliance approved, JP Morgan Asset Management. And I forgot to mention one of the most important things is this is being recorded. So this webinar is being recorded. If you object to being recorded and becoming famous, please drop off. Anyway, so consumer savings and borrowing, personal savings rate. This is something, that I really wanted to talk about. It just shows how, a lot of people know that during COVID, we were just saving money. Most people were still working and saving money and have nowhere to spend that money. And then there was a lot of government stimulus and whatnot. And we just put that in our bank accounts, nowhere to spend that money. And now that money, first of all, it came out that we haven't saved quite as much as initially thought. And that money has been spent down, both because of inflation and because, people just haven't necessarily jumped back into the workforce and they've been spending quite a bit and they've been spending that savings down. Now, household excess savings right now, you see that jump during COVID, but then you see it now declining more than even the average trend, right? So that also, in a one way, the silver lining to that is it helps inflation to come down. It's sad but true that if you don't have money, you can't spend it. And if you can't spend it, it actually pulls down inflation. And then we have revolving consumer credit outstanding. That has jumped up. It's not, it's not terribly high, but it is higher. And one thing to highlight is that we don't have a chart on is a default from, like, for example, auto auto repossessions and auto defaults have increased. That is not just because consumers can't handle the inflationary increase, but also because, as you know, used cars and cars in general just have, shot up in price during COVID. This slide talks about recession. So the first few slides are a little pessimistic. They're concerning in one way, but in another way, a bit positive as it applies to inflation coming down. This one truly highlights how inflation truly is coming down. Don't take my word for it. Just look at the numbers, look at the chart. Inflation is coming down. It might not feel like it because core CPI is still half of 1% higher than it is on the 50-year average, but it is coming down. And typically, it takes 6 months to feel the results of interest rates coming up. And as the Fed has raised interest rates, now you just have to, tag team 6 months later. And if you look at the rolling 6 months, you know that it is not only coming down, but will continue to come down. That's extremely important. So, takeaways. We definitely could head into a recession. That isn't something to be, to try to be fearful about, but something to prepare emotionally, and mentally for, and also realistically prepare for, right? Don't hoard toilet paper. Just know that things might get a little more expensive, and be aware of that, and know that that is temporary. That will come down. We've never had inflation that hasn't come down, even during the Carter years. So that said, I first wanted to now open it up to questions before I bring on our guest. If anyone has any questions, please raise your hand. And you can raise that by going down into the reactions button and raising your hand. Does anyone have any questions? Okay. Then with no further ado, I am going to ask our guest speaker, Marshall. Hi, Marshall. How are you?
Well, I have been down with COVID for the last week, but it so far is mostly just an annoyance. It's kept me away from the office. So I've been working from home. They call it a head cold might even be a little too grand, but that's what it is these days. You have to live with the COVID and do the testing, and comply with California's labor laws.
Yes, yes, definitely. And I did hear that you were down and out, but I'm so glad to see that you're with us and you seem better.
Again, it really hasn't been a horrible thing. I'm not sure why anybody's all that afraid of it based on what I've experienced, but here we are.
Yes, yes. I know it took me out, but you just, everyone's different, right?
And every time it's different, I'm sure.
Yes, yes. So I wanted to start off with just asking you, what are, you've been doing this for, I mean, please, if you can introduce, give a little bit of insight into your background before we begin, and then I'll start with a barrage of questions.
Okay. Just so people know who I am, I'm an attorney. I've been practicing in trusts and estates since passing a bar in 1976. And I have dealt with estate planning, with trust and estate administration, and I do a lot of trust and estate litigation. So I see where a lot of these plans go sour. for one reason or another. And so a lot of that has to do with family dynamics. And so whenever you get involved in this area of practice, you have to be uh, considerate of family dynamics and how people react to each other, and the fact that you're going to be seeing the results of probably 60 or 70 years of sibling tension and remarriages and all the actions that affect families over time. So that's that's what's kept me busy for a very long time and still does.
Yes. And then if you can tell us, how many years have you been in practice?
Well, since 1976, so I'll be 48 years in practice by the end of the year.
Well, you certainly don't look it, Marshall. Um, Now I know that, with your vast experience, and you also do litigation. And for me, that's very important because, um, you're standing behind your work. You don't just do estate planning, the trust and medical directives, wills, and power of attorneys, but you also stand behind it. So if there's any litigation in the future, you will represent the client. So, knowing that you have done litigation, what are some of the most common pitfalls that you've seen people make when doing their estate plan?
Most estate and trust litigation that I run into, I mean, there are always the odd things out there that you don't anticipate, but most of it is a problem of surviving spouse versus stepchildren, blended families, children from different marriages, who have little regard for each other, a spouse who may have little regard for the children of a deceased spouse. So that's one whole category of litigation. And the other major area of litigation is sibling problems. And a lot of these go back to childhood and how families have raised children and all the jealousies and slights and other problems that may go back until these people are 5 or 6 years old and they just never got out of it after 60 years or 70 years. And they're still doing it. And so uh, those are the major areas. I have families that have, let's say, 4 children. 3 of them are independent and self-supporting and can take care of themselves. One child never got out of the house. And so that child ended up taking care of the parents and now feels like they're entitled to a lot more of the estate because the other children weren't around. And of course, that child was making sure the other children weren't around so they could get a bigger share of the estate. So these are the kinds of things I see. I'll never forget one deposition where my client, who was the daughter, pointed a finger at her brother and said, "You killed my canary when I was 6 years old," and broke down and started to cry.
Oh my God.
And,
Yeah.
but that may be somewhat extreme, but it's not isolated.
Yeah.
It
Yes.
does happen. And whether it's fighting over the same guy or the same girl when kids are teenagers, or someone got something special because they got to college and the others didn't, whatever the problem is, these resentments last a lifetime. And the only reason you don't see them when the parents are around is that when the parents are around, people tend to behave themselves more. And then when the parents lose that sort of grip on the family, that's when all of the problems start to show up.
And the emotions. So, um, I have a lot of clients tell me, my kids get along great. They get along great. And then I see them make their children, uh, 2 children, co-trustees of their trusts, successor co-trustees, sometimes even 3. And personally, I say, please, please don't. And they go, no, no, I don't want to overstep my bounds. I want to be respectful. But in your professional judgment, And I'm sorry to throw this question out of left field, but your professional judgment, would you recommend that a client have, let's say they have two kids, have them as co-trustees or assign one as the successor trustee if anything happens to them?
That is really a family by family decision. Very often you create resentment if you don't include them all as co-trustees. And so someone or some ones are left out and they're causing trouble. Sometimes they don't get along and you can't have them as trustees because they won't agree on the time of day. So when I meet with parents, I ask them the question, who do you want to have as a trustee? Do you want your children to be trustees? Do they get along? Will they be able to do this together? And, sometimes I have to ask that question 2 or 3 times before the parents have really thought about it and decided what they want to do. Sometimes the only solution is to bring in a professional, a
Mm,
bank, a licensed professional fiduciary, which we have here in California, uh, as an outsider who isn't part of the family drama. And
yes.
then they can administer the estate and everybody can sleep at night because no one's going to do something that they shouldn't do when no one's looking.
Yes, I've had very great, wonderful experiences with fiduciaries because they are objective. Um, Really quick, I just wanted to mention one experience that I'm having right now. And, I suppose my biggest thing is, yes, I've seen kids that clients thought really got along fantastic, have some issues, when navigating co-trusteeship. But the biggest thing I think for me is that it tends to be way more complicated and sometimes just so difficult when you have two kids, even two kids that get along, be co-trustees. So for example, I have a client and the successor co-trustees are a daughter that's in England and a son that's in New York. uh, that's complicated enough if one of them was trustee, but the fact that both of them are co-trustees. So they actually made a fiduciary. They resigned as successor trustees and made their a fiduciary a trustee. Another example is right now, literally today. I have like three generations of these clients. Grandmother was originally my client, and then the daughter, oh, actually, her three children became my clients when she passed away. And then their children became my clients. Well, two of those grandchildren, sisters who get along relatively well, they they ended up having to be co-trustee on this one trust account that was at a very, very large bank here in LA. And the bank, as large as it was, their protocol, and they refused to compromise on it, per their legal department, had to have the co-trustees, both of the co-trustees come in after her passing together at the same time in order to put them on as co-trustees. Um, yeah, so that was incredibly convoluted and difficult to say the least. So anyway, I just personally, help me help you, clients, please put one trustee on, please, and I will help explain and navigate that to your children. I am not an attorney. I don't give legal advice. Okay. So now, Marshall, uh, thank you for allowing me that monologue. And now we're getting on to the second question. What are some of the key questions that a family should ask an estate planning attorney before engaging with them?
I think the key questions are to find out to what extent the estate planning lawyer really has knowledge of the area. And they need to find out what it's going to cost to put something together. Most estate planning is done on a fixed fee basis. at least for estate plans that don't involve a lot of estate tax planning. Estate tax planning tends to be hourly because you don't know what you're going to be doing until you get into it. And that involves a variety of irrevocable trusts and instruments that we create in order to either fund the estate tax or to cut down the value of the taxable estate. But for most people, and right now everybody has a death tax credit of $12,900,000 before they pay a dime of estate tax in net value. And so you can get pretty close to $26 million of estate for a married couple before the estate tax is currently going to be a problem. So for most people, it's the question is the trust, the pour over wills, the powers of attorney, the healthcare directives, and ancillary documents, transfer the real property. That's the normal estate planning package.
Mhm.
Some lawyers like putting together these generic letters about how to fund the trust, what to do with this, that, and the other thing. And that's really, I suspect, to keep their malpractice carrier happy. I don't think they are read and really understood to any great extent. And so, for me, the estate planning process is meeting and discussing and asking questions that the client hasn't thought about. And so you have to be willing to sit down with the client, maybe on 2 or 3 occasions, in order to ferret out the information that's needed.
Mm.
And so, in order to hire the estate planning lawyer, you need to be able to ask those, basic questions. What is the plan? I mean, what does it consist of? How much is it going to cost? Am I going to be able to sit down with you and talk to you about my kids and my family and what we want to do and don't want to do, and set it up in a way that will carry out our goals? And as I always tell the client, this is your estate plan. It's not mine. There's no right or wrong here. It's what you want to do. I can tell you the consequences, but the decisions are always yours.
Mhm.
And so that's that's what you should be talking to a potential estate planning lawyer about before you sit down and hire that lawyer.
Mhm. Yes, totally agree. So knowing that, you've seen some of these some issues come up, you've litigated, what are some of the most common mistakes that people should avoid when doing their trust wills, POAs, and medical directives?
It really depends on the problems in the family. I mean, most people can do fairly generic estate planning and it will work because most families get along sufficiently well that they will not be fighting each other, and there's going to be a plain vanilla type of distribution. Everybody's going to get their share, and it's all going to work out. And the less you trouble people, the less fees that are charged, and the more you get.
Sure, sure.
So
But you've seen some common, well, you've seen some mistakes, right? Like uh
the
mistake.
area which I think creates for a lot of families continuing problems is that in order to protect the issue of a deceased spouse, the children of a decedent, we will set up trusts so that the surviving spouse has a life estate. And at the end of that life estate, whatever is left goes out to whomever. And so you have this constant tension between the spouse who wants to spend money and support himself or herself and the children and grandchildren of a deceased spouse who are concerned about that money disappearing.
Mm, mm,
And so you have this tension that's never going to go away. And so very often when I have blended families, what I'm talking to the clients about is there a way for the children of the first of you to die to get paid something then? That's what they get.
Mm-hmm.
And then the surviving spouse and his or her children get everything else that's left. Can we set up an islet or an
Mm-hmm.
insurance trust in order to fund what the deceased spouse's children get? And they get that quickly and they're gone from an estate point of view.
Mm-hmm.
And if they want to have a relationship with their step parent, that's up to them, but the trust administration won't get in the way.
So, for those of you who don't know, an ILIT is an irrevocable life insurance trust, and what Marshall is speaking about is if you have, let's say $1 million, an estate that's $1 million. Well, you know what? Actually, make it easy. $2 million. Most of you have that, or more. $2 million, and you would go, okay, this $1 million, that's going to fund a irrevocable life insurance trust, which is going to take that money out of the estate. So what that does is it takes the money out of the estate and funds a life insurance policy in that trust, and it funds it. And then that way, this group of people, they get all that money. Either they get that $1 million, or they'll get this life insurance policy, the value of this life insurance policy, uh, when their parent passes away. The other million goes to the spouse and the spouse's children, so that there's not that constant conflict going on that Marshall's speaking about. Um,
So I mean that to me is a solution that is often there. If you have children who don't get along, a similar solution may present itself. There may be children who can't handle money, and so they need a trust. And so if you give them $1, they'll spend two. Others are responsible, and they're not going to want to have their share tied up in trust. And so we have to tailor the plan for these children, all of whom are going to be somewhat different, and the parents have to be realistic about what they really want for these children and when they should get it and how they should get it. And so these are all questions that are asked during the process. And, very often when you have parents with young children, they don't really know how their children are going to turn out. And so we have sort of generic ways of setting it up so that upon the death of the surviving spouse, the trust divides into separate trusts for each child, and they get their share at different ages, 20, 25, 30, whatever it is. And then as we learn more about these children as they grow up and they find out there's more to life than a fast car, uh, then maybe we modify that trust to take into account that some children grow up faster than others.
Yeah, through an amendment, right? So you can always amend your trust. And if there are major changes, you can do a restatement of your trust. Marshall, we've had conversations before, which I found incredibly enlightening. So thank you. Um, and you enlightened me about one thing that really kind of struck me, that you were talking about, instead of putting percentages in the trust, like, okay, a third goes to this person, 20% goes to that charity, and so on, that instead, it might be wise or possible to do a different method.
Well, what I was talking about is that there are a lot of people who want to leave relatively small percentages of their estate to charity, their church, their favorite animal organization, whatever it happens to be. And so if you have 4 or 5 charitable bequests of 2 or 2.5% each, what you set up is that charity will be entitled to an accounting of the entire trust in order to make sure they get their percentage. If you set it up so that they get a cash amount, let's say you have this $1 million estate and you want to leave 2.5% of that $1 million estate, that's $25,000. Well, if you left them $25,000, once they receive their 25,000, their interest in the trust has been liquidated and they no longer have an interest. And they're not entitled to an accounting. They're not entitled to know why we're selling this property or that property, or why we're investing in this stock or that stock, because it doesn't affect them.
Right.
And so when it comes to small bequests, I usually recommend not a percentage, but a cash amount, which means that if the estate changes a lot in size, you may need to revisit those cash amounts to make sure they are consistent with what you want to do.
Mhm.
But in terms of administration, some charities are extremely aggressive,
I've seen
and they
that,
have
heard
their
that.
finger in every part of the trust.
Yep. One another thing that I have done for clients is, because it can be concerning. You don't know when the market's going to drop, like, it has in the last few days and whatnot, or last year, or when it's going to just pop up. Um, you can allocate an account. So say, for example, let's say you have $1 million in an account, you can take 100,000 of that, put it into a separate account in the trust, in the name of the trust, and you can have a percentage of that account go to a trust. So 20% of that account goes to that trust. That way, the charity will be able and eligible to see the accounting of that particular account, but not the entire trust, just that account. And as that account fluctuates, you don't have to revisit, okay, a certain dollar amount goes to the trust, and what's my total net worth and all of that stuff all over again. You can just set it and forget it, and what that account does is what that account does. So that's just one thing that you can do. You can even do a totally separate account. I've had clients do a totally separate account, and 100% of that account goes to that charity.
Well, a variant of that kind of planning is you write into the trust that the charity gets the lesser of a percentage or X amount.
Fantastic.
And so if you just want to give them their X, forget about the percentage, so you can liquidate them that way. If their percentage has grown too large, or if that cash amount is too large compared to the value of the trust, you give them their percentage.
Sure. So, Marshall, if it were, I know you're not giving any advice or anything like that, but if it were you and your trust and you were giving a small portion to charity out of the different avenues that we discussed right now, which one would you choose?
Usually the simplest thing is simply to set aside a cash amount in the trust itself.
Got it.
You can always set up an account and have TOD beneficiaries, which can include charities. That's another way of doing it. And all they have to do is present a death certificate and take their share. So that would be separate from trust administration. Not everything has to run through the trust. You just need to make sure that what you're doing is coordinated, so that you don't have half the estate going in one direction and the other half going in some other direction, and they're not quite sure why.
Sure.
So people use joint tenancy, they use survivorship, they use TOD accounts. There are even now TOD deeds on property. Not that I recommend them, because they are difficult, and I'm not sure whether you'll get title policies out of them. But there are a lot of ways of handling an estate without the formality of a lot of documents. I tend to like the formality of a document because I can take it to court and it's easier to handle if I have to. But it doesn't mean that everything has to go that way.
Thank you. So my next question is, while most people likely will use a revocable trust due to the flexibility allowed, can you discuss briefly when an irrevocable trust may be more appropriate to use?
Irrevocable trusts tend to be used for tax planning. there's usually no good reason to use an irrevocable trust when it's really just a will substitute. The revocable trust is just fine. And so the way we use trusts to save on estate taxes, where that's important, is that we can use certain types of trusts to expand the death tax credit. And the way we do that is that we come up with a split interest trust so that the income or the right to use a piece of property stays with the grantor for a period of years. And then the remainder goes out to the beneficiaries. And so one of these is called a QPERT, Qualified Personal Residence Trust. So let's say you have a $10 million property that you're living in. It could also be a vacation property. And so if you hold back for 10 years the right to use the property, and then it goes to the remainder beneficiaries 10 years from now, that 10-year interest discounts the value of the property, reduces the gift. So you end up giving away $10 million of property if you live through the whole 10 years or whatever the number of years it is, and then the children take it over, and they may have had an estate tax cost of 5 million out of the 10, depending upon the interest rates at the time. And there are IRS rates that tell us what we use to value the discounted, delayed, or deferred interest. And so that's one of the major ways we use these types of trusts. It could be done through a grantor retained annuity trust or unit trust, and come up with the same general way of doing it. The thing you have to be careful about is you have to survive the limitation on the number of years in order for it to save you an estate tax.
Right, right,
You
right.
can't push it out too long beyond your life expectancy and expect it to work.
Yes, I did a QPERT, or I didn't do it, but I recommended an estate planning attorney years ago for a client who had a sizable um, uh, house that was valued at at the time more than $7 million, and that was over the estate tax limit. Anyway, attorney did a QPERT, qualified permanent residence trust, and did a 3-year qualified permanent residence trust. So after 3 years, um, he did have to pay kind of rent to his kids, which he didn't like, but it was actually an incredible benefit, uh, both because in paying the quote unquote rent after 3 years to live in his own house, he reduced his overall size of his estate by giving giving the kind of rent, but also avoided a huge tax liability when he did eventually pass away, and the house went to the kids and it was subsequently um, sold. So anyway, yes, so I definitely believe in certain irrevocable trusts in
Yeah.
certain cases.
There's
Um,
there's a classification of trusts that are referred to generally as SLATs, spousal lifetime access trusts.
yes,
They were very popular in the 2012 time period because everybody was afraid that the death tax credit would go from 5 million to 1 million. And of course, we're going to be looking at a similar possibility at the end of 2025 when the then current estate tax limit falls in half under the current legislation. So that's something that may become very popular in 2025, setting up spousal lifetime access trusts. And the way you set them up is you take the community property, divide it into separate property pots. Then each spouse sets up a trust for the other spouse with some differences between them. So it doesn't look like reciprocal trust. And the spouse is the life beneficiary of the other spouse's trust, and then it goes to whomever. And that is thought to be a reasonably good way of preserving both the death tax credit then available and preserving access to whatever the spouse needs So the gift does not necessarily impact lifestyle.
Mhm, mhm.
And so that's something that we may see more of. I've acted as an expert in several cases in the last couple of years where the spouses end up in family court because they're getting divorced. And some spouses saying, I didn't understand any of that. No one explained it to me. It was my spouse's lawyer who set all this up. I didn't know I was giving away half of everything. So
Yeah.
all this needs to be thought through. I had one case where I was guardian ad litem for children of a trust that was set up for their benefit by the parents with about $100 million. The husband was a hedge fund manager. And then the parents were getting divorced, and the children now had an interest in the whole thing because they were ultimately the owners of the entire estate being divided up. So it was a circus.
That sounds like a mess.
So this is where estate planning can run across family problems,
Yes.
and you have these potential messes that nobody really understands outside of the context of we're going to save some estate tax.
Yes. Yes.
And
Um,
then, of course, aside from the irrevocable trusts that we discussed, the insurance trusts and so forth, there are the entities we set up to create discounts, where we set up an LLC over a piece of property, give away some units to the children. Parents are in control and manage everything as if nothing has happened.
is
But
that an FLP, Family Limited Partnership? Is that what you're talking about? Or an
that would be
LLC?
one variant.
Okay.
But more are now using LLCs because they're more flexible and they have
Mhm,
some easier tax issues than even a partnership does.
mhm.
And they're both better than an S corporation from a capital gain point of view. So that's
Sure.
important.
So if you
And
have a property, for example, sorry, Marshall. So if you have a property, for example, an investment property or a second house, maybe your kids live in it, for example, would you recommend setting up an LLC in that case?
if it's investment, I wouldn't set up an LLC for my own house and use it for tax planning. But for an investment property where children are renting, or you have third parties as renters. LLCs have the effect both of creating the ability to create discounts 20, 30, 40% from the estate tax valuation that would otherwise occur. And at the same time, if there's a lawsuit developing on that property, it will help to protect the overall estate from the damages out of that lawsuit. And one of the things that we run across all the time now is there are a lot of, especially commercial and industrial properties that have pollution issues.
Hmm.
And there's nothing that can rack an estate more than that, especially if we're dealing with groundwater contamination
Yeah,
and
so
trying to clean that up.
so if clients have like a commercial real estate property, for example, they should really be cognizant of that and how and the entity that owns that, right, in order to limit their liabilities.
One of the most common areas of environmental problem in a shopping center is the cleaners, because they
Wow.
use chemicals to dry clean your clothes, and they're supposed to do it in such a way that the chemicals never hit the ground, but accidents happen.
Sure, sure. So just really quickly getting back to, for example, you mentioned if you own a property, a second property, not your primary residence, a second property, maybe you lived in it before, but it's over 5 years and you haven't lived in it for over 5 years and your children live in it. And then at that point, would you set up an LLC or an FLP, a family limited partnership, or would you just own it outright? You would just own it. What would you do? Or you put in a trust, a revocable trust? What would you do?
At this, well, it depends on the value of the overall estate. So if we're not worried about estate taxes and we have friendly tenants in the form of children, I probably wouldn't worry too much about it. I would make sure I had, reasonable amounts of liability coverage and umbrella coverage, which
Mm-hmm.
is inexpensive
Mm-hmm. Highly
compared to the
recommend
amounts
that.
that are involved,
Mm-hmm.
and handle it that way. Uh, Entities cost money every year. They require a certain amount of maintenance in order to work. So I wouldn't just have an entity to have an entity.
Mm-hmm. So in that case, you might just have it in your living family trust, your revocable trust, and get umbrella insurance protection and call it a day.
For something like that, as probably the least expensive and simplest solution to work with.
Yes, got it.
There are a lot of expensive and inconvenient solutions that may solve a particular problem, but nobody will want to live with them.
Sure. Well, we're coming up to the end here, but I wanted to ask you, is there any other advice you would like to give?
My basic philosophy has always been that if I can come up with a simple solution that doesn't cost very much, that's the best solution for most people. And so I've never been a great fan of dynasty trusts where we try to hold assets in trust for several generations. I think that they create a lot of work for lawyers, which is fine, I suppose. But I don't know if they serve families that well. Uh, we use foundations for very large estates in order to have the family retain some level of control over the assets. And some foundations are very elaborate, like the Keck Foundation. Others are less so, but they all do a fair amount of charitable good. And the family becomes involved with that and can draw fees from it and enjoy the wealth that way. I mean, there are a lot of things we can do in estate planning that will cut down and eliminate the estate tax. It's a question of what the family really wants to do in order to accomplish that. So I can guarantee a no tax estate. The question is whether you want to live with it.
Thank you so much, Marshall. Really, really appreciate your time and your expertise. And for all those on the call, we make available a list of estate planning attorneys, which Marshall is on, in case you do have that need, not only for a trust, medical directive, power of attorneys, wills, but to update, amend, restate your trust or revisit it, or for some good old-fashioned legal advice, which everyone truly is in need of. So feel free to contact us for that. We'll make it available to you, as well as the complete slides of Guide to the Market. Thank you so much, and everyone have a great day. Thank you, Marshall.
All right, thank you.